Hey guys, welcome to my legal classes. This is Ganesh Pujari and you are seeing a lot of smile on my face because this is our 100th video in the series of Indian Evidence Act. We were discussing chapter 7 of Evidence Act, which is all about burden of proof covered between section 101 to 114A. And in the series of chapter 7, this is my 9th video where we are going to discuss section 114, which discusses about court may presume existence of certain facts. Here we are discussing 9 different circumstances where court may presume certain aspects, and then we are discussing the exceptions also with the form of illustrations. Now, before getting into the first slide, remember there is one amendment section, that is section 114A, which is also very important. So I am making an independent video for that particular section. And this section, as I have already told, there are 9 different circumstances discussed. So it will be definitely going little lengthy, and I have few case laws also in the last 2 slides. All you need to have is patience, and with that I am taking you to the first slide. Section 114 basically discusses about court may presume existence of certain facts. The provision says the court may presume the existence of any fact which it thinks likely to have happened regarding being had to the common course of natural events, human conduct, and public and private business in their relation to the facts of the particular case. The section is quite easy, and to make it further easy, I have my chart below. But before getting into the chart, I would like to give a simple illustration. Imagine a boy is walking on the road and due to some obstacles he falls and he gets hurt. The moment he gets hurt, what does he do? He will definitely say, Ma. Now that is what we say when we are hurt. Maybe our mother tongue is different, but whatever mother tongue we have, we remember our mother and call Ma or something like that, which is one of the normal human conduct or common human conduct. Now that is what precisely discussed under section 114. It is not just discussing about normal human conduct, it discusses about common courses of natural events, human conduct, as well as normal public and private business. In these 3 circumstances, if something has happened, the court may presume that the things must have happened in that way. That right is there with the court. Here, one very important aspect we need to observe is the court may presume. It is not shall presume. Court has the option to presume or not to presume. Basically, the court may presume the existence of any fact which court thinks that the same has likely to have happened because it would have happened normally in the common course of natural events, or normally in the human conduct, or normally in the public and private business. That is what we need to understand from section 114. Saying so, this is not a conclusive section. Here, the parties can prove otherwise for every other circumstances that we are going to discuss. I have said as many as 9 circumstances are there, and for every 9 circumstances, there are opportunity to counter from the parties by explaining the circumstances. So basically, these are rebuttable. That is what we need to understand. That is why I have given in the black boxes. It is not mentioned here, but when we go further, we will understand. Here, parties can prove otherwise under what circumstances it happened, and by proving that it is rebuttable. That is what we need to understand from section 114, and from here let us discuss all the 9 different aspects along with illustrations, and finally let's move to case laws. Here comes the first presumption or first circumstances. Here we are discussing 2 very important aspects. One, theft, the other one, dishonestly receiving stolen property. Now the presumption says when a person is having stolen goods with him, the court either treats that as the person who is having it has committed theft or he has received the stolen goods knowing that it is been stolen. Now, these are the presumptions that the court may make. Saying so, there is one exception also. In the normal course of business, if someone has received that goods, in that case, that becomes an exception. To understand this, I will give an illustration. Imagine Mr. X along with other colleagues of him has committed bank robbery, and after bank robbery he got his portion, and from that portion he gives some money to Mr. A to buy certain amount of goods from Mr. A's shop. Now A takes the money which is basically robbed by Mr. X and his friends. Now A is not aware, and in A's business it is common that people give money and he gives change. As a part of his common business, he received the stolen money or robbed money without even knowing it. Here we cannot say that A knew that he has received the stolen goods. That becomes an exception because in the normal course of his business he would have done anyway. So that's what we need to understand from circumstances number 1. When we are discussing about circumstances 1, please also read IPC section 378 to understand what is theft, and also read IPC section 411 to understand dishonestly receiving stolen property, and both these sections are available in my slide. Take screenshot and read through, and with that I am taking you to second circumstances. The second circumstances discusses about the presumption when an accomplice gives the witness to the court. Now, what is an accomplice? When any crime is committed by 2 or more people, every single person is called accomplice or the participant in that particular crime. Now, they are doing it together. Now, when a crime is committed, if any one of them from those who have committed the crime, if he or she gives witness, that has certain amount of weightage, which is what discussed under Indian Evidence Act section 133. We are going to discuss that in detail when we are discussing 133. But for now, you remember that it has certain amount of weightage. However, court may presume that the same has unworthy of credit or cannot be considered until and unless the same is corroborated in material particulars. The person who is giving witness, the accomplice who is giving witness, has to give material facts. Only then the court may consider his witness, otherwise it may consider it as unworthy. That is what the second presumption. Saying so, if that has sufficient corroborated material particulars, in that case the court will consider. Here we have 2 illustrations which are very interesting and with 2 different perceptions. Now, in the first illustration, what happens? There are 2 people, one Mr. A and the other one is Mr. B. Now, one common thing about them is they both have very high good character. Now, together Mr. A and B has assembled a machinery. Now, while assembling, there was certain amount of carelessness by Mr. A and B, and because of that carelessness, one person died while working on that particular machinery. Now, A is held for that crime. Now, when B comes to court, he becomes the accomplice because he was also part of the assembling of that particular machinery, and he says, yes, we have done certain amount of carelessness, and because of that only a person has died. Now he gives complete evidence of what carelessness that they have done, what was the process that they have followed. Now he explains everything, and by doing that he corroborates the entire material particulars, and he also says that he too was the part of it. Now this is where court will accept the evidence given by the accomplice. On the other hand, in the second illustration, what happens? There are three people who are caught for a particular crime: Mr. A, Mr. B, and Mr. C. Now, when the police ask them questions separately, they all are telling a different story and they say Mr. D is the one who has committed this. Now, here they are unable to corroborate the material particulars of the crime because they all were saying different story, and this is unworthy of credit or this is not reliable. So in that case, the court will not consider such evidences. That is what we need to understand from this particular illustration. With that, I am taking you to the third circumstances. The third illustration is on bill of exchange. When a bill of exchange happens between two individuals, one accepts, the other one endorses, or one accepts, the other one gives. Here, the court may presume that the same has happened with good consideration for both the parties. That presumption can be done by the court. Saying so, if one of the party proves that it was not so, there was no good consideration, in that case, if the same is proved, then such presumption becomes rebuttable. Like for example, in the illustration, there is one businessman by name A and he gives a bill of exchange to Mr. B. Maybe for bill of exchange, we'll keep the example of check. Now a businessman gives a check to Mr. B, and here B is a quite young person and he is a very ignorant person, and he receives that check completely under the influence of Mr. A. Here, if all such circumstances are proved, in that case, this particular presumption can be rebutted. That is what we need to understand. The may presume condition, what we have discussed under this particular circumstances, becomes shall presume condition under section 118 in the Negotiable Instrument Act 1881. When we are discussing Indian Evidence Act, the court may presume that both had good consideration, but as it is bill of exchange, this is one of the very important aspect from the Negotiable Instrument Act 1881, and there under section 118 it is very clear that court shall presume that there is due consideration and all the other aspects like date, time, transfer, endorsement, stamps, holder in due course, etc. shall be presumed as under section 118 of the Negotiable Instruments Act 1881. That is one thing we need to always keep in our mind. With that, I am moving to the next circumstances. The fourth circumstances is about a thing or state of a thing. Now, like for example, river Kaveri is there. How it flows. All of us know that how river Kaveri flows. The court may presume that yes, river Kaveri flows in the same way. Or river Ganga. Now, every one of us know how exactly river Ganga flows. And the court may presume that yes, even for this state, river Ganga flows in the same way, because it is been same for so many years. Saying so, it is rebuttable if someone says that there was heavy flood and now the river has changed its course of flowing. If that is happened, like if the flood has happened over a period of time and the river has changed the direction, that can be proven, and unless and until it is proven, the court may presume that the thing or the state of thing is the same. That is what the circumstances D discusses about. The fifth circumstances that the court may presume is the judicial and official acts have been regularly performed, because this is common in the public business. When we are discussing about public and private business, the judicial and official acts are getting regularly performed is one common thing, and the court may presume that they are taken care. Saying so, under exceptional circumstances, if they are not being done, the same can be rebutted, or someone can prove that no, such judicial or official acts have been not regularly performed. That can be proved otherwise, and until and unless the same is proved, the court may presume that such judicial and official acts have been regularly performed. The sixth circumstances where the court may presume is related to the common course of business. When the question is related to the common course of business, the court may presume that the same has been taken care. Now, like for example, if someone has posted a letter, the court may presume that the letter has been delivered. Now, that's what happens in the common course of business. However, if someone disproves the same, the presumption of the court can be rebutted. Like for example, A posts a letter to Mr. B, but B says there was certain amount of interruption, and because of such disturbances, the letter which has been posted by A has not reached me. Now, if B proves that, in that case, the court's presumption can be rebutted. The seventh circumstances is related to evidence. When any person is having an evidence and when the court is asking him to produce the evidence, if he is not agreeing to produce it or if he is withholding such evidence, the court may presume that such evidence is unfavorable to the person who is withholding it. Like for example, Mr. A has an evidence and court asks Mr. A to produce that evidence, but A is withholding the same. In that case, the court may presume that the evidence which A has is unfavorable to Mr. A. That can be presumed by the court. Saying so, there is an exception. Here, if the person who is withholding such evidence saying that by giving such evidence, the reputation of his family is going to be damaged, that is why he is not giving such evidence, the same assumption can be rebutted. But the illustration, if you read, which says a man refuses to produce a document which would bear on a contract of small importance on which he is sued, but which might also injure the feelings and reputation of his family. The importance of such evidence is very small, but in the end, if it is going to injure the feelings and reputation of his family, he might withhold it, and the same needs to be considered by the court, which is about the seven circumstances. The eighth circumstances is quite similar to the circumstances which we have discussed under 7. There we have discussed about an evidence. Here we are discussing about an answer. Here what happens, a person is asked a question, and as for law, he need not to answer that question. He is not compelled by law to answer that question, and the person withholds the answer. He is not giving answer to the court. In that case, the court may presume that the answer is unfavorable to him. That presumption can be made. However, if the person proves that the answer is going to cause certain amount of loss which is not connected to that case, if that is being proved by the person, the same needs to be considered by the court. That is about the 8th circumstances. The last and the 9th circumstances is the court may presume that when a document creating an obligation is in the hands of the obliger, the obligation has been discharged. Now, what is this obligation, obliger, etc.? Let us try understand this with the help of simple illustration. Imagine there is one Mr. A and one Mr. B. Now, A needs 2 lakh rupees loan and B is ready to give the loan, but he needs a document for his security. So what they do? They prepare a bond. Now, in the bond, A mentions that he has taken 2 lakh rupees loan from Mr. B and on so and so date he will return it back. He signs the bond and gives it to Mr. B. Now, who has the obligation to pay? Mr. A has the obligation to pay and he is the obliger. Mr. A is the obliger and he has signed the bond and given to Mr. B. Now, on any fine day, if the document is back in Mr. A's hand, the court may presume that A has paid back the loan and that is why B has given the document back. That presumption can be made by the court. That's all about the 9 circumstances. Saying so, if B is proving that no, A has not repaid any money but he has stolen the document, if B proves that, in that case the court presumption may be rebutted. That is what we need to understand from the last illustration. So basically, court may presume when the document is back in the hand of the obliger, the obligation is completed. However, if the person who has given that loan, if he proves that no, it is been stolen, in that case the presumption can be rebutted. That's all about the 9 circumstances, and with that I am taking you to case laws. The first case law that I have is Tulsa versus Dugatia, where two individuals, a male and female, stayed together for a long time like husband and wife, and the presumption here is they are husband and wife. And if somebody is saying among them or anyone else that they are not husband and wife, the same need to be heavily proved. That is about the first case law, because if two individuals, a man and woman, are staying together, it is a common human conduct that they will stay only when they are husband and wife. That is about the first case law. The second case law, when I discussed all the 9 circumstances, I told that such presumption is rebuttable, and for that the example that you can give is via this case law where it was held the same, that is Sobha Haimavati Devi versus Setti Gangadhara Swami. The third case law, that is Ashok Kumar Uttam Chand Shah versus Patel Mohammad Asmal Chanchad. It was held that genuine and correctness of document have to be proved by a person believes upon it by cognate and direct evidence. The fourth case law is very interesting as far as section 114A assumption is concerned, that is Wasant alias Roshan Sogaji Bhonsale versus State of Maharashtra, or you can call it Wasant versus State of Maharashtra. This is a classical case for section 114 clause A, where the recovery made some days after the dacoity does not raise a presumption under section 114 clause A in respect of the offense of dacoity. There we have discussed about theft and receiving stolen property, but that is immediately after the theft and receiving stolen property, but not after some days. After some days, if somebody is having that property, it cannot be presumed by the court under section 114 clause A. That is what held here. The next case law, that is State of Karnataka versus David Rosario. Here almost section 114 is repeated in the judgment. That's just an example for that particular aspect. And moving to the next case law, that is Lalta versus District. Here, when oral and other reliable evidences are satisfactorily giving evidence that the pair lived together as husband and wife, merely because family register does not show them as husband and wife is not clinching evidence to deny their relationship of husband and wife. That is what held here. It is not very important to be mentioned in the family register. If they have lived together as husband and wife, that is sufficient to prove that they were husband and wife, which is what held here. And the last case law, that is Mukund alias Kundu Mishra versus State of Madhya Pradesh. It was held that a court may legitimately draw a presumption not only of the fact that the person in whose possession the stolen articles were found committed the robbery, but also that he committed the murder. If robbery and murder has happened together, and if the police finds the stolen article with a particular person immediately after the robbery, it is not just presumed by the court that he has committed robbery. The court can also presume that the murder is also done by the same person, which is what held in this particular case law.
Pause. We need to take pause. Sometimes when we work a lot, we might lose quality. So we need to take pause.
Yes, Nishan, you are right. Sometimes when we work on a particular job or assignment continuously, because of the monotonous way that we are working, we might lose quality. So it is very important for us to pause for some time and look back what we have done and then look for improvement for our further activity. So it becomes very important to take pause in between and then progress.
With that, I'm concluding this session. Please subscribe our channel. Please like, share and comment our videos. Thank you. Bye-bye.